Okay, Shannon, put us on. Okay, Airway Welding versus Rogers. Counsel, state your appearances.
Good afternoon, Your Honor. Bruce and Osensi on behalf of the plaintiffs.
Joseph Spiegel on behalf of the defendants.
First, housekeeping. The scheduling order, I thought I signed this. Did you get one back?
I never received it back, Your Honor.
Joseph, I did not either.
All right, well, it looked familiar when I printed it out. Usually I would expect that when something like this comes in that somebody would print it out and bring it to me to sign. So,
Right.
I will sign both of these today, okay?
Great, thank you.
Thank you, Your Honor.
In fact, I'm going to do it right now while I'm thinking about it.
When you say both of these, you mean the case management and scheduling order and the protective order?
Right.
Okay. Thank you.
Next item.
Your Honor, I had provided extra true copies when we mailed those in on July 2nd. Does the court have those available to send on to us?
This looks familiar. I thought I signed these, but they weren't in the file. They weren't in OnBase.
Okay.
They could be just waiting to be filed downstairs, but I guess there's no harm in having two. That's better than having none.
Thank you, Your Honor. We'll make sure that we get copies and we provide same to defendant's counsel.
Also, it occurred to me as I was looking at your file prior to today that I never got back to you on any suggestions for a third attorney / director to resolve stalemates until this matter can be resolved. I have a couple local names. Jeff Anderson would be one. Bill Nichols would be one. I don't know how active Bill still is, but I think you'd find both of them, at least from my past experience of working with them as a lawyer. They're both smart guys. They're both experienced in business and corporate matters. They're level-headed. So those are a couple of suggestions for you. I'll give you a chance if you want to think about that and make sure there aren't any kind of client conflicts there. But those two names, I think could, either one of them would serve well. If I were picking someone myself to do this for my company, I'd be very comfortable with either one of these gentlemen. Okay, so my apologies for not getting back to you sooner on that. I do remember you asking me about it the last time you were here. And anyway, so what we have today then well, that's a good question. Are there discovery issues for me to address today? I read some correspondence and a lot of exchange about being able to agree on how you're going to do depositions and when and where. Is that one of the things that's on my docket today to address?
No, it isn't, Your Honor. This is Joseph Spiegel. The only two things that were on the docket for today was the motion to seal the record on the motion to disqualify, which there's apparently no objection. I submitted a draft order in Word format. I noticed a couple of typographical errors. One, the face of the order says order to show cause. It should say order to seal. And in item 1, it should say to be sealed. And I think that from my conversation with the clerk's office, was they put it in a confidential file. But I think the word seal and confidential are equivalent. So if all the court has to do is enter that order, I've already served counsel with the motion and the brief to disqualify. I could always send them another copy. I will file it, and I'll get a hold of the clerk's office to determine how it has to be quote, filed. And then it'll have to be set for a briefing schedule and for a hearing. So that is one housekeeping issue. The other essentially small housekeeping issue is.
Well, let's stay with the sealed file, because I'm not supposed to simply agree to seal a record just because neither party objects to it. The Supreme Court, if we can see the rule, I can't remember. Do either of you remember it off the top of your head? It's 8 point something.
It's 8119I2. It has to be for good cause, which is defined in the rule. It's where the underlying motion refers to matters that should be excluded from the public record. And what we have said in our motion is that this particular motion contains personal confidential information, including a prior judicial order, which was deemed as part of a criminal record that was expunged. And therefore, there is no necessity under any real basis to let the public see all this. So I think we've set forth a good faith showing under 8119I2B. The decision to keep the incident motion under seal is consistent with the purposes of the Holmes Act and HIDA.
So the specific language of the court rule requires that the court has made a finding of good cause in writing or on the record which specifies the grounds for the order, and there is no less restrictive means to adequately and effectively protect the specific interest asserted. So as to the grounds or whether good cause has been shown, the rule says I must consider the interests of the parties, including whether there is an allegation of domestic violence, the safety of the alleged or potential victim of the domestic violence, and the interest of the public. Obviously, the domestic violence doesn't apply here. The specific interest of the parties, in this case, the one whose record was expunged. So when we talk about the expungement of a record, I understand that essentially means it's as if you have no criminal record.
That's correct.
Help me and I get that. So my assumption is it would be treated similar to a juvenile record in that respect?
That's correct, Your Honor.
I know juvenile records can be considered by a sentencing judge. It's not like they're invisible and outside of his purview. How is a HIDA conviction entitled to more protection than a juvenile conviction would be?
Well, there are other issues that are raised in the motion to disqualify that involve the personal information of the family of the Rogers, which I don't believe either plaintiffs or defendants want the public to see. And I don't believe there's any public interest served by this particular motion being made available to the public. And again, it seems that we have met our burden. It is just this one motion and this one brief. I think that under the Supreme Court rule and the Michigan rules of court, I think we've met our standard.
So I also have to be able to address whether or not there is a less restrictive means to adequately and effectively protect the specific interest asserted. Have you explored whether there's a less restrictive means available?
This is Joseph Spiegel. I don't believe there is. There are exhibits attached to the motion and brief. I think it's pretty clear that the motion and brief of that information makes it very difficult for the court. I'm not sure that the court would be able to receive the motion in camera. And consequently, I'm not quite sure what other methodology could be used on this very limited motion and this very unique situation.
Right, and I don't have, well, hold on. You submitted a proposed order with your motion?
Yes, I did. I submitted it both in Word format pursuant to the court's protocol through the court's office, and I submitted a hard copy. Like I said, I did note on the Word, on the document, it's a Word document, it could be easily changed. Instead of order to show cause, it should say order to seal. And on the second page, item number 1, I see a typo, and then it says to be sealed. It should be sealed.
All right, well, I will make the specific finding on the record that this motion may be sealed. I find that allowing it to be a public record not under seal would defeat the personal interests created and protected by the Holmes Act. This is not such an issue that the public interest would be harmed in any way. Anyone, of course, who feels differently about that has recourse to file a motion to unseal if they thought they had a good reason for doing that. And for that reason, I am going to grant your motion to seal.
Thank you, Your Honor.
Your Honor, if I may, for purposes of qualification, just for clarification, obviously we do not oppose the actual motion to seal, but we do intend, obviously, to oppose the motion to disqualify. And so I'm wondering if we can get some type of a time frame as to when that will be designated as actually received by the court and when a hearing will be held so we can file a timely response.
I concur with counsel.
I received an electronic copy of that. It hasn't been, I don't know where it's actually been. I've seen it already. So it's just a matter of getting a response to it and setting a hearing date.
Is there a proposed hearing date, Mr. Spiegel?
I usually call the judge's assistant and get a hearing from her, which I can do after this hearing, and then send you a note on that.
All right, that's fine.
Any particular time frame, Mr. Inocencio, for you to file a response?
I would say probably the first week of August.
So set the hearing for second week of August?
Yes, Your Honor. In all likelihood, the week of August 10th. I have to be, I could do maybe the 11th. What time would the hearing be set, Your Honor?
I'm pulling up my calendar. I could hear it at 8:30 on August 13th.
I can do that, Your Honor.
I can do that, Your Honor. And then I will have, I'm sorry, counsel, when did you say you're going to file your response?
In accordance with the court rule, as far as whatever date the court decides on for the hearing. So if it's August 13th, that'll be our hearing date, and I will file it in line with the deadline.
Okay, because I'll have to have a couple of days to reply.
The court will provide for that, I understand.
All right, so just file a notice of hearing for that date and time.
I will do so, Your Honor.
Your Honor, if I may, we also have defendant's objections to the proposed order. But as this court indicated prior to the discussion relative to the motion to seal, there are some discovery issues that I would like an opportunity to address briefly when we finish the discussion relative to the objections.
And this is Joe. I don't think it's the time and place to address any discovery issues. I think we will be filing appropriate papers in that regard. There has been some correspondence. I think there's a necessity to respond to that correspondence and in a proper forum, proper motions, responses to the motion should be made. So I rather not get into any discovery at this point in time. And I think we should simply move on to this order where we really don't have much of a disagreement except to items 3, 4, and 5 of council's order. Essentially, if the court looks at our version, I think it more correctly addresses what transpired on June 8th, 2020. In particular, the motion to disqualify.
Hold on a minute, Mr. Spiegel. It looks like I've got an incomplete file. I'm not seeing either one of your proposed orders. Could you each email those to me right now so I have them in front of me?
Absolutely, Your Honor.
I will have to go on a different computer to do that, Your Honor. But I don't email directly to Your Honor. I can only email to Ms. Clark because that's the protocol, and I can email it to Ms. Clark. In fact, she already has it. I'd already sent it to her as part of the protocol.
I'm sure she's got it, but she's not here, and I don't have it.
Okay.
I need to see it.
Your Honor, I can provide the court with both.
Great. Please do that.
Your Honor, if you can do you want to provide the court's email? I have it right here. Well, no, I think I have your old one.
You got it?
I think I have your old one in here. Go ahead.
All of our email addresses follow the same protocol. Mine is rlaFlamme@mijackson.org.
Okay, I just shared a file with you, which is our proposed order. It should come up as a Dropbox invite.
Oh, by the way, I just noticed when I check my email, I don't typically watch it while I'm on the bench, but Patty sent me a note saying that, yes, indeed, I did sign those two orders. I thought I remembered doing it. She's got them on her desk, so those will be the forms that get issued for the protective order and for the scheduling order.
Okay,
And let's see, I don't see your email yet.
okay.
I've got an email from Patty because she's listening, so be careful what you say about her. She says she had forwarded it to me back when it came in, and she's looking for it now.
That's okay, Your Honor, I have it right here. Okay, so I sent you two separate emails through Dropbox, which should include one version that's dated 2020.0618. That's the plaintiff's proposed order. And the other email is dated 2020, the other document is dated 2020.0622, which is the defendant's proposed order.
Well, I'm waiting for that to come through. Oh yeah, okay, here we go.
Your Honor, the document I sent you that's dated 2020.0618 from our office is just the order. The one that I sent that's defendant's proposed is their motion, and their order is attached thereto as an exhibit.
Well, it's asking me to join Dropbox.
Okay, let's do it a different way. Give me 1 second, Your Honor. Okay, Your Honor, I just sent a different email with a link to the document and the PDF attached, so you shouldn't have to join Dropbox for that document. And I just sent the other document as well.
Doesn't look like it made it through our firewall. Let me try again. Oh, here we go. It opened that time.
Okay.
So I've got one. Let's see if I can open the other one. So I got the one prepared by you, Mr. Inocencio.
Okay.
And the one prepared by Mr. Spiegel. Okay. So now, Mr. Spiegel, what specifically were you arguing?
It's with respect to plaintiff's counsel stating in item number 3 on his order that the court ruling on March 3rd provided for the dissolution of BRIT is held in abeyance. That is not reflective of what the court said in its hearing. Provisions 3 and 4 of plaintiff's proposed order do not reflect what was said, and therefore we had proposed that there is no reference to the disqualification, to the dissolution. Rather, this court just didn't address it. It only said it's premature. The only other issue that we had was that the motion to disqualify Airways Counsel, you rendered it essentially moot. You didn't deny it, you just rendered it moot. And with respect to the motion on breach of fiduciary duty, you made no ruling on that, as is reflected in the transcript, and therefore we propose that it state that this court makes no ruling on defendant's motion to dismiss plaintiff's claim for breach of fiduciary duty and reserves the right to address the issue at a later date. And so consequently, I think our order, as is reflected in the brief, more accurately reflects the ruling made on June 8. As the court stated, I'm also going to order both the corporate entities dismissed without prejudice. And then it says that takes care of the problem of Mr. Inocencio's conflict, i.e. it renders it moot. And then with respect to the proposed order, with respect to the removal of the caption, essentially both parties agree that both corporations should just be dismissed without prejudice. But it's the provisions of item 3 and 4. You said on the issue of dissolution, I am satisfied that it would be premature for the court to order that. In fact, it is an ultimate relief that is being sought without the grounds firmly established for granting summary disposition. I'm not prepared to do that today. So there's no need to include any language regarding, as in item 3 of plaintiff's order, that this court ruling on March 3, which provides for the dissolution of Airway and BRIT, is held in abeyance. That's not what the court ordered. The court specifically said it's premature, could be a motion for summary disposition. So there's no need to address that in the order that we submitted, and then there's no need for plaintiff's counsel to have that in the order. And similarly, there's no need to address the issue of the appointment of a receiver. Again, the court stated that it was premature, and therefore there's no need for items 3 and 4 of plaintiff's proposed order. And then finally, as we have said, the defendant's motion to disqualify was just rendered moot. So I think the order that we have submitted more accurately reflects what the court ordered on June 8. And I would suggest that since we agree on items number 1 and 2, and not number five, that the court adopt what we have proposed as numbers 3 and 4. Make it very simple and easy.
Mr. Inocencio?
Thank you, Your Honor. As this court is aware, binding Michigan precedent provides that this court speaks through its written orders. And as the court will recall, we were back before the court on March 3rd on the issue relative to our request for an appointment of a receiver and for the dissolution of the entities. At that hearing, this court agreed and stated that there would be a dissolution of the entities and that a receiver would be appointed unless there was an agreement reached via mediation within 60 days. Of course, I'm paraphrasing, but the court recalls that discussion that we had. This court also at that time requested that Mr. Spiegel present an order relative to the outcome of the March 3rd hearing, and that did not happen within the applicable court rule time of 10 days, and he actually never tendered it, and so we did, and then we noticed it up for a hearing, which is why we were back before the court on June 8th. The reason that we have included the language in the order that we have proposed is because we want the record to be clear that at one point, this court did indicate on March 3rd, 2020, and this is why we've included it both in paragraph 3 and paragraph 4, that the court's ruling on March 3rd provided for the dissolution of those entities and the appointment of a receiver, but that decision is now being held in abeyance. For some reason, unknown to me and completely inexplicable, defendants do not want the court record to reflect what actually happened on March 3rd. I don't understand it, but this court speaks through its written orders, and the court should accurately reflect what happened in its orders. We also don't have any type of a situation here in the transcript that reflects that the preliminary order, which was the preliminary injunction, which was entered by this court on March 3rd, should be extended to December 31, 2020. I have no idea why Mr. Spiegel included that in his proposed order, but he did. This court did not order that. It all comes down to integrity, Your Honor. And when you start including provisions in orders that were not actually provided for by the court, it doesn't make any sense, and it creates a waste of time and expense. And this is all much ado about nothing. There should be no reason at all to include a provision like Mr. Spiegel has included in the last paragraph of his proposed order. In closing on this issue, I would also note that a couple minutes ago, Mr. Spiegel suggested that the court should enter the order that states that this court makes no ruling on the defendant's motion to dismiss plaintiff's claim for breach of fiduciary duty and reserves the right to address the issue at a later date. That's in our proposed order. That's paragraph 6. That's not in his order. So he's suggesting to you that that's the language that should be included. That's the language that we proposed. When this court is put under an obligation to review competing orders, the competing order that's tendered has to suggest why our order is inaccurate. That did not happen. There's nothing in our proposed order that is inaccurate, that does not accurately reflect what happened in this case. I would suggest exactly the opposite for defendant's proposed order. There is specifically a provision in here extending this court's previous order of March 3rd to December 31, 2020. There's no basis for that. That never happened. And this court should not grant the order that's been tendered as the competing order by the defendants in this case. And in fact, what this court should do is tender the proposed order that we tendered to the court on June 18, 2020. And I have no other comments on that issue, but I would like an opportunity to address the discovery issues once this issue has been resolved, Your Honor.
Your Honor, if I may, the court specifically stated, if you'll note on page 2 of my brief, during the hearing of June 8th, this court explained its ruling on the question of dissolution and the appointment of a receiver as follows, and I quote, "On the issue of dissolution, I'm satisfied it would be premature for the court to order what, in fact, is the ultimate relief that's being sought without the grounds firmly established for granting summary disposition." So essentially the court said, I am not ordering the dissolution of these companies, period. It's that simple. That's what the court held. Secondly, I don't know where counsel is getting this business of December 31st, because what I sent to the court as the issue extending the preliminary injunction, it just says item number 5, the preliminary injunction entered in this matter on March 3rd is hereby continued until further order of the court. I don't know where counsel's getting this other language. Maybe he got a different order, or maybe he got a draft that he shouldn't have. If he had called me up, that would have been fine.
Your Honor, I'm looking at the proposed order that I received from counsel, and the last paragraph says, the court's March 3, 2020 preliminary injunction order is hereby extended through and including December 31, 2020. I received this from him. That's where I got it.
Well,
That's why I don't understand it.
that is not
But the
exhibit.
order,
That is not exhibit.
the order,
That a man
hold on. Mr. Inocencio, the proposed order that you sent me today reads exactly as Mr. Spiegel says, paragraph 5, the preliminary injunction entered in this matter on March 3rd, 2020 is hereby continued until further order of the court. I don't have whatever other order you're referring to in front of me.
Your Honor, he sent me two. I'm happy to provide this one to the court as well. This is not my document. This is his document.
But he's not advocating today that I enter that order. He's advocating that I enter the one that you sent me.
That's correct for paragraph 5.
All right, gentlemen, here's what I'm going to do. Our courthouse closes now at 4:30. I'm about to lose my staff. I will ponder both of the proposed orders, and if I feel it appropriate, we'll mark up one or the other to reflect what I believe needs to be reflected in the order. All I'm going to say about the discovery issues, because I don't want to hear any more argument today, is depositions can take place using remote technology. You guys need to figure out dates and times. The amount of animosity that I'm seeing between the attorneys in this file and the amount of paperwork that's being filed is disproportionate to what is, I believe, reasonable under the circumstances. What's happening is the amount of legal fees that are being invested in this case are going to make it that much harder to resolve it. You folks need to be using your efforts to reach a resolution. Find that third tiebreaker vote and get that person in place so that the corporation can function. That's what needs to happen. You're spending far too much time with the multiple motions and objections to orders that are being filed, generating paper than you are into reaching a resolution of the case. With that,
I agree, Your Honor.
I'm closing the record today. Well, if you agree, do something about it. Have a good day, gentlemen.